Tell us maybe the legal position around prenuptial agreements.
In England and Wales, prenuptial agreements are not yet legally enforceable, although the Law Commission has recommended that they should become so. However, over the years, the court has attached more weight to them, culminating in a very important decision which was made by the Supreme Court in 2010, the case of Radmacher. The essential principle from that case is that where a couple enter into an agreement freely, understanding what they're signing up to, that the agreement will be upheld unless, at the time of any breakdown of the marriage, it would be unfair to hold them to it. So that's the essential Radmacher principle. What is clear from the way the decisions in subsequent cases, the way the law has been interpreted since Radmacher, is that it's not possible to have an agreement which prevents a needs-type claim, a claim to cover somebody's income needs and housing needs. You can, however, prevent a sharing claim. So it really means that they're only going to be relevant and are likely to be upheld in totality in big money cases.
Since courts are bound to be fair to both parties in the event of a divorce, is there any reason why somebody who is financially dependent, such as a stay-at-home wife or husband, should sign up to a prenup or any other marital agreement? And if that becomes a condition of the marriage, isn't that a kind of coercion? And should that party then not be legally represented?
Well, it will always be necessary for both parties in the negotiations to have separate legal representation. But what's important to bear in mind that in most prenuptial agreements, the situation comes about because a party who has more wealth, who is the economically stronger partner, is marrying somebody with less wealth. And that's the reason why he wants the agreement. He wants to prevent a sharing claim against his wealth if the marriage breaks down. And that person, the economically weaker person, usually the woman, is going to be in a difficult position in any event because she will probably be living with this guy. Most people cohabit before they get married. And if she doesn't get married, she will be in a very vulnerable position if their marriage breaks down because cohabitees have virtually no rights. So although, yes, you can say it's an element of coercion because he will be effectively saying that he won't marry her unless she signs the agreement, her position is actually going to be more vulnerable if she doesn't sign an agreement and then get married as a mere cohabitee. Also, she will have a lawyer to protect her interests, and the role of that lawyer will be to try and negotiate an agreement which is fair to her, meets her needs. And so there will be some advantage to her. I think she will have clarity in terms of signing up to the agreement, but clearly the main beneficiary will be the person with the most wealth. That's how prenups work.
Finally, it sounds sensible, but the question many people will be wondering is, first of all, who pays for it? And secondly, how much could it cost?
Who pays depends on the circumstances. It's up to the couple to negotiate that. In a situation where very obviously one is wealthier than the other, then it would be usual for him, because it's usually him, to pay for both. How much does it cost? Well, that depends. It probably costs a lot less than the legal costs that would be incurred in a very acrimonious divorce. And the costs depend on factors such as the extent of the negotiations, how much the couple agree or disagree, how complex the asset base is, and other factors such as whether they need to involve other foreign lawyers. For example, if they're thinking about moving to another foreign country, you may need to get advice from a foreign lawyer. However, it's worth doing if you have assets that are worth protecting, both in your own interests and then also in the interests of other people, such as children.